Thank you. My name is John McCarthy. I'm the State's Attorney for Montgomery County. I'm going to speak first. I'm going to invite Mr. Turner, Troy, Jacob and Sarah's father to speak. And at the end, we will entertain some questions if you have them either for Troy or myself. Catherine Hoggle was found incompetent to stand trial for the murders of her two children, Jacob and Sarah. Ms. Hoggle has been held on those charges, or a combination of charges related to the abduction of these children and for the murder of these children for the past 8 years. And I think everyone knows she's been held at a psychiatrically secure hospital called Clifton T. Perkins in Jessup, Maryland. The ruling today was made by Circuit Court Judge James Bonifit. He is the chief judge of the administrative judge in this circuit. Over the past 8 years, Ms. Hoggle has been established by the doctors at the hospital close to 30 times as being incompetent to stand trial. The doctors at Clifton T. Perkins did not at any point in time find her competent to stand trial during the years she's been there. We attempted during the course of this hearing to challenge those findings by a careful and detailed examination of the hospital records that we think contradicted in some instances the conclusions reached by those doctors during those years of treatment. Under Maryland law, there is a limited period of time within which the state is given the opportunity to attempt to restore someone to competency, regardless of the charge against you. That time officially would have run tomorrow. As a result of the statute that controls in this matter, by operation of law, and it is controlled by Maryland law, not controlled by anything that we can do here in this courthouse or the State's Attorney's Office, the charges were dismissed against her today by Judge Bonifit in court about 5 minutes ago. Competency to stand trial has two aspects. I think Judge Bonifit referred to it in his closing comments. As Troy had respect for what Judge Bonifit ruled, I thought it was a very reasoned decision that he made, even though if we disagreed with his conclusion as to prong two. There are two prongs to competency. Do you understand the process? Do you know what the lawyers are? Do you know what you're charged with? Do you know what the penalties are? Throughout the entire time she's been at Perkins, she's always satisfied prong one. There's a second prong that says you have to be able to assist your attorney in your defense. Our argument during this hearing was that the question is not just the ability to assist, it's the willingness to exist. And as you heard from the comment of Judge Bonifit, there were issues of secondary gain. The fact that she wanted to be incompetent, the fact that she did not want to return to jail, and during the course of the hearing, that she wanted in some way to regain some access to a third child whose parental rights have now been stripped from her. The court ruled the state did not satisfy prong two of the two-prong test. But there still remain several important points for the community to know about this matter. Ms. Hoggle will not be free in the community. As we just witnessed a few minutes ago, she will be involuntarily committed by an order signed by this judge because she remains a danger to herself or others. As was noted by the judge in his ruling today, as she was given the opportunity to involuntarily commit herself, she would not do that. She is committed by court order today. She will remain quite possibly even in the same hospital. It's not up to the court or to anybody here in this building to determine where she's housed. The State Department of Health and Mental Hygiene will determine where she is. That could be remaining at Clifton T. Perkins. I can't tell you the final answer. It's for a state agency to determine. As long as she remains a danger to herself or others, she will remain at the hospital. We now lose the opportunity or the right to be kept informed of how she's doing. Judge Bonifant noted in his hearing that she was evaluated every 6 months. We won't get those evaluations anymore. We will not know how she is progressing because she has HIPAA rights. She has privacy rights that attend to her medical records. And so that is one of the challenges we'll have, because we will not be as informed about the continued nature of her treatment in the hospital as we move forward. She will remain involuntarily committed until doctors determine that she is no longer dangerous. We will not be involved in that process. That is a process that occurs within the hospital, and it's a determination solely of the doctors. Should she be released in the future, if there is a point in time where she no longer remains a danger to herself or others, it is important for the people to know that under the statute that dictated that the charges had to be dismissed today, we have the right to recharge. There is no double jeopardy that applies here. This is not a double jeopardy situation. The state has the right to recharge. I will tell you, as long as I'm state's attorney, it would be my intent that if she is adjudged to be safe to be returned to the community, the circumstances would be such that we would recharge her, even if we have to revisit the issue of competency again. On a personal, I have a great deal of sympathy for Troy. Over 8 years, we've gotten to know each other a bit and have talked many, many times. I have sympathy for the friends and family and the supporters that Troy's had. And he's got a lot of supporters in this community that care about these kids. For all those people in the community who love these kids, tough day. My personal hope is that we will not have justice ultimately denied, but merely delayed. It is my honor to introduce to you Troy Turner.
First, a lot of you I've seen a lot over the years, and thank you for keeping my kids out there and helping us with that part. I guess the best place to start is where we're at. As I said in the courtroom, for anyone who's in there, this system is broken. Whenever someone can murder 2 children and then be treated as a regular patient, be given more rights than the kids or the survivors around them who they've affected, there's something really wrong. When someone can stand in a courtroom, mischaracterize everything that comes out of his mouth, and then try to call someone else a liar, I don't need to call you a liar to someone else. I'm telling you to your face, you are. There's something wrong here. When this is allowed to move forward this way, it's a completely broken system and it needs to change. We're going to be in front of the state legislative bodies in Maryland. We're going to try to make these changes. If we can't save my kids, we're going to save as many as we can. But what I can tell you is this. As I said in the courtroom, this fight's not over for me and my family. We're going to continue to pursue justice in whatever way that we can from this point. The fight changes from justice for the 2 that are gone to saving the one who's here and keeping him safe, because, well, this isn't a thing where she's not going to be back out in the community again. For anyone who believes that, pay attention to the other cases from the same time frame that are going on now. I'm pretty sure you'll see Miss Avery walking around at some point. That's the demon assassin, for those of you who don't know. This isn't something where people are, they're going to sleep on it. They're saying, well, she's never going to get out. They're going to hold her. No, she could be right next door to you and your kids very soon. I give it within a year probably, because now the charges are dropped. She's going to have the willingness to get better. And she's had the ability the entire time. I have spoken to her. I have heard what she has said. I heard what was in the records in the courtroom, and what I can tell you is, I've watched with my own eyes her sitting there communicating with her attorney. Just yesterday, she brought in a piece of paper that she had highlighted herself and handed to him. There's information that he asked me about on the stand that he could have only gotten from her. There's no other place to get it. So as far as meaningful communication goes, I would say it's definitely there. But yet, this woman is allowed to kill 2 children and then be put in a hospital. She belongs in jail. She belongs in prison. Everything with this is wrong.
Troy, do you believe that Catherine Hoggle is faking it?
In what part? If you're talking about her mental illness, no, I personally have had her committed. She has mental illness. If you're talking about her competency, 100%. She has told me so.
So you think she's faking her competence?
She's faking being incompetent, yes. She has so much as said it. She has said she has been advised to remain incompetent. She will tell you what she can and cannot talk about. She has said in her medical records that she wants to remain incompetent. She has said it to the staff. It came out in court. She has said it to many people. So definitely.
Troy, you've been talking about this day for a very, very long time. Did you go into this day with any hope beyond the
Very little. There's always some hope, until there's not. It's like it's been pointed out as if it's a detriment to me that I tried to hold on to hope that my kids were alive. I held on as long as I could until it just didn't make sense anymore, and it's obvious that she killed my children. When we came in here, we were expecting what we got. I honestly, I don't blame Judge Bonifant because he's bound by the system and the laws and the way that things are written. I believe if things were let into the court that were not, that were factual, just the truth, I believe that he probably would have been able to say differently. But because what he was given, I think that he probably did the best he could, and I wasn't, up there BSing him when I told him I do appreciate him. I think he's probably a very good man who tries to do the right thing.
Do you see any prospect, circumstance, the way the system works, treatment at hospital, anywhere that she might be persuaded or encouraged to solve the mystery of where your children are?
Here's what I would say to that. As far as where their bodies are is a mystery. As far as what happened, who took them, who did it, there's no mystery there. No, and here's why I would say this. There's no reason for her to. So her motive for gain, there is none for her, and that's what this is going to be about. Also, she's protected in this circumstance. As long as she stays incompetent, she's protected. Nobody can come after her. There's nothing that can happen. So there's no reason for that. And as far as even bringing people to competency, one of the things that I think one of the most shocking things I heard in the courtroom was that they're really not given real treatment until they're found competent. So I don't know how you expect to bring someone to competency. They're given classes on incompetency. They're given paperwork that shows incompetency leads you to home. And then if you have someone who's profoundly ill, how do you expect them to get better without real treatment? So, like I said, the system is broken from the top down. It's broken on both sides, and I don't think it's news that our healthcare system is broken with mental health. But I think Perkins is probably one of the best examples you could cite. I would say there's no question if she's competent. My question is Perkins' competency. I think they're incompetent.
And Troy, people often forget that there's a third child that you share with Catherine. What are your concerns now moving forward with this third child and parental rights and things like that, and for possibly getting released?
Well, here's what I'll tell you. They're dropping the charges against someone. I'm not going to go too deep in that. As you know, I keep him pretty much out of this. What I'll say is this. My family members are in danger of her if she walks. Anyone would be in danger. But from things that she has said in court and things like that, and or that she has said in the record, I have no reason to believe that I don't need to do whatever I have to do to keep him safe.
John, can we ask you a similar, somewhat on the lines of the questions you heard earlier, but maybe the state didn't prove its verdict differently than has been done to argue that second prong?
We got probably somewhere between 2,000 and 3,000 pages of medical records. We mined through those records. We wanted the court to allow us to go through those records. You know, you can come up with a conclusion, but our position was to challenge a conclusion, you have to kind of follow the facts through the course of the years of treatment and the medical records to see how we got to the conclusions. By not allowing us to look into the records in that fashion, we were not able to show how we think there were some false conclusions made. You know, obviously there were things said in court about, I mean, what Troy just mentioned about in the conversation he had with her, that she had been advised. He asked her specifically, what did you do with the kids, and did you kill my kids? And she said that she had been advised not to answer those questions. Someone advised her to do that. Through consultation with an attorney, she was cooperating with and following his advice. The records were replete with situations where before she was asked, do you want to do treatment, do you want to take the medication? Let me talk to my lawyer. During the course of this hearing, we heard that she simultaneously, while she was being sat there incompetent to stand trial for these murders, participated in a civil case over in Virginia where her parental rights were terminated, and spoke during that hearing. And there were replete references in the records also to her wanting to file appeals, knowing when the deadlines were, afraid that she had missed deadlines for filing. You know, she was involved in another civil proceeding where she demonstrated competence. At the same time, they were claiming incompetence in this matter. Those were the things we were looking at. I think a deeper look. We were hoping for a deeper dive into years of records so that we could adequately challenge the ultimate conclusions made by the doctors. We asked that, I think Judge Bonifant mentioned, we asked the judge to take judicial notice of the Perkins file. The court declined to do that. That information is in those files.